Honor, that would be great if I could do that.
Okay. Go ahead, sir.
Thank you. May it please the court. I'm here on behalf of Thomas Foster Sr., who today turns 93 years old. Mr. Foster, back in March of last year, there was a petition for incapacity filed against him. And I won't bore you all with the facts. I'll try to go through it quickly. Shortly after, or at the same time of the petition for incapacity, there was a petition for emergency temporary guardian. And there was a stipulation by his court-appointed attorney the day after that court-appointed attorney was retained, prior to having even met or consulted with Mr. Foster, which stipulated to the emergency temporary guardianship with regard to financial matters. And that was subject to a 90-day period, at which time it would expire. In August, Mr. Foster reached out to me and asked me to substitute as counsel for him. A petition for substitution of counsel was filed, and that was denied based upon the fact that the emergency temporary guardianship order had given the court had provided to the emergency temporary guardian the right to contract on behalf of Mr. Foster, which is why a petition for substitution was sought.
So he couldn't, would you agree that during that emergency temporary guardianship, he could not contract?
I would agree that during that emergency temporary guardianship, he could not contract on his own, which is why we sought substitution. We sought.
Doesn't that mean that he could not contract with you?
Yes, Your Honor. He could not contract with me. I believe that during that period, he could not enter into a contract, which is why I sought leave of court to substitute for the court appointed attorney pursuant to 744-331-2B, which says, and I think it's very important, an alleged incapacitated person may substitute his own counsel for the court appointed counsel. At the time that we sought substitution, without question, Mr. Foster was still an alleged incapacitated person. Never had there ever been any adjudication whatsoever of incapacity. Therefore, pursuant to 744-331-2B, as an alleged incapacitated person under Holmes, presumed to be competent until clear and convincing evidence has been heard by the court and the court has made an adjudication that he lacks capacity, he is still an alleged incapacitated person and has the statutory right to substitute his own counsel for the court appointed counsel. That's really what this hinges on. There are a number of reasons why the ETG order, there were issues with the ETG order, which I've laid out and I can say for rebuttal, but notwithstanding the ETG, notwithstanding the fact that emergency temporary guardian is there to protect his rights, there is nothing that takes away, until he has been adjudicated with incapacity, there is nothing that takes away his clear statutory right under 744-331-2B to substitute counsel. And what's interesting is the response relies upon the Jasser versus Seda case as somehow authority for its position. In the Jasser case, what was significant is that it was clear, and I'm referring to page 244, 97 Southern 3rd, 244, where it states, although the court did not make a factual determination of incapacity, it appointed Barfool as emergency temporary guardian because the court found that the evidence showed that Seda was diagnosed with high-stage Alzheimer's. In Jasser, what's important is the court conducted, during the ETG proceeding, conducted an evidentiary hearing in which a neurologist testified, in which the ward's daughter testified, in which the ward actually testified, as well as others. But even so, in the Seda case, when there was a petition for him to substitute counsel, both the ETG and the ward's court-appointed attorney argued that Seda did not have the right to choose his attorney. Nevertheless, the court permitted him to hire his own counsel. And what was also significant about Seda, which is incredibly significant here, is that on page 247, citing to the Keene case, that an attorney cannot waive an adjudication of incapacity on behalf of their client. And in this case, according to the record, and we've put it on there, in March of 2020, at the very first hearing for the ETG before Magistrate Samus, Mr. Kouskoutis, the court-appointed attorney, states on the record he had not even met with or spoken to his client, yet stipulated to an ETG for 90 days. And Magistrate Samus says she is not making findings. The only evidence pertained to the where his assets were that was conducted during that hearing. But Samus said, I will simply put in that there's prima facie case in order to appoint an ETG if you believe the proceedings, but you all are welcome to challenge this because there was no evidence as to capacity whatsoever. That lasted for, so Mr. Kouskoutis stipulated without having met with Mr. Foster. That lasted for the 90 days. Then, without following the appropriate requirements under the rule and under the guardianship statute, the rule is 5.648, there was never any petition by an interested party showing that conditions still exist for an ETG. Under 5.648, an interested party may file a petition, but must show conditions still exist and shall serve it on the ward's attorney. Thereafter, the court can extend for 90 days. However, under 744-301, the emergency temporary guardian statute, the court may only appoint an ETG on its own if there has been no petition for a guardian filed at the time of the adjudication of incapacity in the incapacity proceeding. There's no statutory authority or rule that says that the court may on its own extend the ETG. Moreover, there is no record evidence that any interested party complied with Rule 5.648 to extend the ETG. Nevertheless,
Mr. Dunman?
Yes, ma'am.
Let me stop you there, because I've noticed in these types of cases that this sort of creates a real jurisdictional conundrum. And I'm not quite sure what to do about that. So maybe you can help me work through it. What typically happens in a situation like this is you've got substitute counsel who wants to come in to represent the alleged incapacitated. And what winds up happening is through the label of challenging the denial of their motion to represent, they start challenging the underlying ETG or determination of incapacity. The problem is, how do we have jurisdiction to review any of those underlying determinations? For example, you're arguing the merits of whether the ETG should have been entered. The problem is that we're not on appeal from the entry of the ETG. Any appeal of that would be untimely. And I understand why you're doing it. And it creates this jurisdictional conundrum that jurisdiction is the one thing we can't get around. So whether it's fairness or equity or whatever, we either have it or we don't. So help me understand why we would have jurisdiction to entertain your argument about the validity of the ETG in the first place.
You know, Your Honor, great question. And I probably fell into the trap that I promised myself I would not do, which was really go into the ETG, because irrespective of the ETG, statute 744331 2B states an alleged incapacitated person can substitute counsel. So where I fell into the trap is barring an adjudication, and clearly there is no adjudication. There is nothing in the record adjudicating Mr. Foster to be incapacitated in any manner as of the time he sought to substitute counsel. I should not even fall into that trap. The
Let me ask you this.
order does not apply. Yes, Your
Let me
Honor.
ask you this so I make sure I understand, because I heard both your points. And now, is one of your fallback arguments that the ETG should not have been extended, though, and therefore action taken by the court consistent with an ATG that was in effect should not have been taken? And is that a fallback argument you're making, though?
Yes, Your Honor. I filed a notice of appearance when the ETG order expired.
So your initial argument is that regardless of whether the ETG was properly entered, 2B and 744-331 gives the person who wants to hire you the right to his own counsel. But leaving that aside, another argument is that the ETG was improperly extended, and therefore your subsequent filing as a notice of appearance on his behalf. And I think there was a third filing. There were three filings, right? There was a substitution of counsel, notice of appearance, and then what was your other filing to?
There was actually the first was pursuant to 6215L, which says that an incapacitated person retains the right to counsel. My first motion inadvertently used that statute. In August, we had the hearing, court denied it, then filed a substitution pursuant to 744.
Anyway, but there was a juncture at which your when I call it the fallback argument is that regardless of whether he ought to have been hired, had the ability to hire you during the ETG was improperly extended.
Yes, Your Honor, because even if there had been an adjudication in the ETG where there had been an evidentiary hearing where there was an adjudication to some degree of incapacity at that time, then perhaps there could be merit to, well, the court has adjudicated incapacity. So that's why even if you had an appropriate adjudication in the ETG order, once it expires, no matter what, then Mr. Foster had the right to retain counsel. So not only during the pendency of a petition for incapacity under 744331 does he have the right to substitute, but once the ETG order expires, even if there had been some degree of adjudication, he still then has a right to hire, to contract.
Was it correct that the statute doesn't, I think there was some debate and the arguments that the statute doesn't require, one of your arguments was the findings required to extend, and that in the opposing parties have argued that no findings are required. The initial findings are fine as long as there is good cause, and I'm not quoting it correctly necessarily, but so if that's the case, why was it an improper extension? If the court need not to have made additional findings of the danger?
Well, for two reasons. One, I do think that there must be, the rule says that whoever seeks to extend the ETG must show. So file a petition and must show in that petition the conditions still exist and shall serve that on the ward's attorney. There was no petition to extend. There was no allegations or any showing whatsoever. So that's why that was one. Then number two, when the second extension, when the second ETG period expired on September 20th, that's when Mr. Foster signed an engagement agreement. The next day filed a notice of appearance, and thereafter the court on its own entered an order non-pro-tunc asserting that the ETG would start on September 20th, the day that the second extension ended, and therefore go up through December. So
Mr. Denman, just to let you
non-pro-tunc-
know, you're getting into your rebuttal time now.
Okay, then the non-pro-tunc order was invalid for the reasons set forth. Bottom line is due process, and going back to jurisdiction, without arguing the merits of the underlying ETG order, there is no question that in this record, there is zero adjudication whatsoever incapacity against Mr. Foster. And therefore, under 744-331, he has a right to substitute. He's still an alleged incapacitated person. He has a right to substitute. And secondly, notwithstanding that, upon the expiration, he had a right to contract. Thank you very much.
Thank you, Mr. Denman. You'll have 4 minutes remaining. And is it Ms. Jamo or Hamo?
Jamo.
Jamo, all right. Ms. Jamo, please proceed.
Thank you. May it please the court. Good morning, your honors. My name is Caitlin Jamo, and I, along with trial counsel Brandon Ballou and Caitlin Powell, represent Thomas J. Foster Jr., the son of Mr. Foster the ward, who respectfully requests that this court deny the petition for cert. Our initial position, although we'll be happy to address the arguments raised here today and in the reply brief, but our initial position is that this court should deny for either one of the two reasons that this court cannot find Mr. Denman has established either of the elements required for a petition to cert to be granted. Specifically, number one, that the trial court did not depart from the essential elements of law when it denied the motion for substitution of counsel, because at the time Mr. Denman was purportedly retained, Mr. Foster did not have the right to contract. And
No, so let's just cut right to the chase. 744-331-2B. The alleged incapacitated person may substitute her or his attorney for the attorney appointed by the court. Why doesn't that apply?
Your Honor, it applies in the sense that we're not saying it doesn't apply. It's just that it doesn't grant a right to counsel where there's an ETG or an emergency temporary guardian appointed. So if I may take a step back, there's two ways for an individual to lose rights in the context of a guardianship. Number one, through the ETG statute 744-3031, or number two, through the general process of appointment of a guardian. And that's where 744-331 subsection 2B applies. So yes, it applies in the sense that he did not lose his right to contract as a result of being an alleged incapacitated person. However, he did lose his right to contract as a result of the March 19 or the March 20 order appointing an emergency guardian, and specifically identifying that his right to contract and his right to sue and defend lawsuits had been removed at that time.
Help me out, Ms. Jamo. What are you reading within 744.3301 in any of its provisions that supplants the unequivocal direction of 744.331-2B? In other words, your statutory argument appears to be, well, this falls under the emergency temporary guardianship statute. Fine, but that does not become the exclusive and only statute that you look at in a guardianship proceeding. And all the more so because at the point in time that we're focused on here, Mr. Foster is only alleged to be incapacitated. It has not been shown, it has not been proven. So what in 744.3301 supplants and gets rid of what I read as a direction in 744.3312B that an incapacitated person can substitute their counsel?
I apologize for speaking over your honor. We would refer to subsection 1, which specifically permits a trial court, a magistrate, which then adopted by the trial court, to remove rights from an individual, an alleged incapacitated person, albeit that language is not specifically used. But it specifically identifies that a trial court may remove rights from an individual when specific findings are made. We agree with Mr. Denman that at no point—
Subsection 1 of 744.3031?
Subsection, yes, Your Honor. And we agree with Mr. Denman that up until a month or two ago, Mr. Foster remained an alleged incapacitated person. there was no determination of Mr. Foster's capacity or lack thereof. At that point, he was an alleged incapacitated person. However, the ETG statute specifically allows for the removal of a right and the appointment specifically.
That's true up to a point, but you would agree that the court's authority to remove rights, all the more so in an emergency temporary guardianship proceeding, is limited and circumscribed by whatever else is in the statute. In other words, the judge can only do what the stat and can only remove rights within the confines of the statutory directives that are put before them. If, in other words, so if the statute says they retain the right to substitute counsel, that is not something that the judge can remove, correct?
Correct, Your Honor, except we would argue that these two statutes one does not supplant the other. One does not trump the other.
I agree. And that's what's troubling me, is because you have an unequivocal direction in 744.331 that says they get the right to substitute their own counsel up until you have the adjudication. But I'm not seeing anything that says what would give in an emergency context any authorization to a court to take that statutory authorization away.
Why don't you point us to the precise language in 744.3031 subsection 1 or any other? Now, I understand the inference is that a guardian over a person or property or both would presumably mean that that individual can't dispose of his or her property by contract or otherwise. Could you just, am I correct? Am I following you? Or is there other provisions that illuminate that phrase for the person or property or both guardianship? I mean, I can draw an inference, but let me know if you're talking about anything more specific.
No, Your Honor, the second line may appoint an emergency temporary guardian for the person, property, or both of an alleged incapacitated person, Your Honor.
Right. So then we have that, and the inference, which probably is drawn not only from what what we all kind of the common parlance or what everybody kind of knows what a guardian is, but elsewhere in the statute, which shows what a guardian does when it has a guardianship of personal property. Is there other statutes that more emphatically show that when a guardian over personal property is appointed, that person loses his or her right to contract?
It's more that it's identified in the orders that appoint an emergency temporary guardian. It specifically identifies that the individual.
So the court has the authority under 744.3031 to appoint a temporary guardian, and there is some flexibility. The judge can say, well, you can't get married, but you can pay your gardener, or whatever. And if the order appointing the guardian says you can't contract with anybody, then that authority has been properly exercised in derogation of the express right in 744.331 2B that the alleged incapacitated person may substitute his or her own attorney for the appointment by the court.
Correct. And I'll identify, just for purposes of clarity, that here the order, which is seen in the appendix to the initial petition on page 17, specifically it adopts the magistrate's the magistrate's finding and specifically removes that right to contract. But taking a step back, it wouldn't make sense, if I understand Your Honor's question correctly, it wouldn't make sense for both the individual and a guardian to be able to exercise the right to contract. And specifically, we look at the purpose of 744.3031, which gives the right to a trial court to appoint an emergency temporary guardian if these high level of factual determinations are made. That's in the context of trying to protect an individual from potentially imminent harm, imminent danger, that physical or mental health or safety of the person will be seriously impaired, similarly with their financial affairs. So the whole purpose of this statute, 744.3031, is to protect the individual by removing those rights when there are certain factual determinations that are shown.
So if I understand your argument correctly, then it's that, well, one of the authorizations is to remove the right to contract. And so that in itself has to supplant the explicit statement in 74431 that you can substitute counsel. But there's kind of there's an assumption there, which is that all attorney representation turns on a contract, and that's not necessarily true.
The court in Jacobson versus Busco specifically looked to, which is the 3rd DCI of 2018, specifically looked to and analogized the entering into a contract and the hiring of an attorney being a specific subsection of that. So
sure. No. I mean, without question, that is how it's usually done. My hang up here is that exclusive? I mean, can an attorney represent somebody without a contract?
Your Honor,
the answer is yes.
I don't know that there's any sort of specific authority that would permit from an ethical perspective. I mean, yes, they wouldn't have a representation agreement in the sense of an agreement to pay
right.
them.
Actually, from an ethical standpoint, it kind of swings the other way, because it's based upon the point of view of the client or prospective client, whether or not an attorney-client relationship has been established. An attorney-client relationship can be established just based on communications. You don't even have to have a contract in place.
Absolutely, Your Honor. And if we look at this either in an ETG context or even in an alleged incapacitated context, and specifically here when we have Mr. Foster, when Mr. Foster, there was a determination that there was the risk of imminent danger or harm specifically to his property and the danger of being wasted, misappropriated, et cetera. When you have particularly vulnerable individuals who are the subject of an ETG, it becomes problematic to then allow them. The whole purpose of the ETG is to protect them, and it becomes problematic to allow them to be able to control that relationship, Your Honor, and dictate that relationship through the communications. That's the purpose of 744.
So that seems eminently reasonable. But throughout this appeal, this case, throughout the statutes, there is a tension, and that leads to a begging of the question problem. And it's intuitive, yes, that there is a problem, but the statutes can't solve all the world's problems. There are merely trade-offs. There are no solutions, there are merely trade-offs. And what the legislature seems to have done is give the right to an alleged incapacitated person the right to his own counsel. So yes, there emergency temporary guardianship. There is a problem, a potential policy problem with allowing someone subject to emergency temporary guardianship to enter into a relationship that we would presume only those with capacity should be able to enter into, and that's with an attorney. But the legislature said that someone who's merely alleged incapacitated has that right. That's one reading of in prior materia of the two statutes. Now, but I wanted to dovetail into another issue that has to do with the motion to dismiss, the voluntary dismissal. I put that in quotes for reasons everyone probably understands at this point. And that is this begging of the question issue. It's fascinating to me in your filings, post perfection filings about the voluntary dismissal, how much emphasis was placed on the fact that the trial court voir dired Mr. Foster Sr. and how much emphasis was placed on the fact that he acquiesced or agreed to a voluntary dismissal at a time conveniently right before he was adjudicated and incapacitated. And this goes to the issue. The issue is this is all about whether he's incapacitated. And that is why there's a tension, right? That's why there's a tension between the person's rights who's merely alleged to be incapacitated. So in a sense, the begging of the question is, well, you know what? He didn't have the right why shouldn't he be able to hire his own counsel in proceedings that are meant to determine whether he was incapacitated? And your argument is because he was incapacitated. And that persists. That begging of the question still persists.
Your Honor.
We don't know when he was incapacitated, when he wasn't incapacitated, but the chronology, in one sense, really supports Mr. Foster in this appeal. And I say Mr. Foster in this appeal because he's represented by Mr. Demon in this appeal.
it's unclear, Your Honor, whether or not he is, and that's really to the heart of Your Honor's question in terms of the dismissal. The purpose of having Mr. Foster and the highlighting of Mr. Foster's testimony before the trial court is more so not because he had the right to direct, but rather what his actual wishes were. And that's something that is taken into consideration regardless of a determination of incapacity, regardless of status of alleged incapacitated or determined incapacitated. The ward or the alleged incapacitated person's wishes are ultimately supposed to be taken into consideration even after a guardianship has been appointed. So Mr. Foster's testimony is relevant to what his wishes were, specifically his direction and his agreement to the stipulation, which included the dismissal of this appeal. Well, I'll also highlight in our response to the objection to the voluntary dismissal on page 6 of that appendices, the court went further beyond even the order approving of the stipulation and said the court's individual discussion with Mr. Foster Sr. satisfied the court he was entering into the stipulation with the advice of able trial counsel with whom he is satisfied and understood the terms after discussing them with his attorney. Again, the purpose is not that he had the ability or the right to make this determination. That determination and that right was held by his guardian, Ms. Radulovich, who also stipulated and engaged in that stipulation, but rather it goes to his wishes. And Mr. Denman is here as purported or nominated attorney for Mr. Foster as a result of his position that Mr. Foster has in fact expressed his wishes and his interest in Mr. Denman continuing or proceeding with representing him. However, I want to make sure I address the interplay between these two statutes and highlight that the two statutes do not have to compete, but rather they work in tandem because these are one of two ways that someone's rights can be removed. And it's either through an ETG or through the general guardianship process. So under 3031 or 331. And Your Honors, in terms of being concerned about the ETG statute supplanting this right under 331 subsection 2B, the concern would be the opposite or the contrapositive really, which is should the court be inclined to find that an ETG statute cannot remove the right to contract, which would then prevent the individual from hiring private counsel, would in essence say that there's right in an exception.
You did it again though, right? I mean, your whole argument about how it works with 3312B is that hiring an attorney is entering into a contract. Having an attorney represent you is entering into a contract. Maybe it's not. Most times it is, but it doesn't have to be.
And isn't that exactly why Mr. Denman sought appointment by the court as opposed to simply coming in as, hey, I'm the new hired lawyer? It's because they can exist together. And even if Mr. Foster had agreed, had lost his right to contract, he still retained the right to substitute counsel of his choosing. So it really, I mean, they're two separate things. And the ETG did not deprive him of that right to choose his own counsel. It's just his own counsel then had to be substituted in for appointed counsel.
And if months and months later, the court can go through the process of asking Mr. Foster whether he wants to voluntarily dismiss his appeal, why couldn't months and months earlier the court have addressed Mr. Denman's request to be appointed, and at that time can ask Mr. Foster whether indeed Mr. Foster wanted to hire Mr. Denman? So, and then we still goes to the chronology problem. That problem exists. That could have been error, and then only now do we have to decide whether that's harmless, whatever. But why couldn't the court have asked Mr. Foster whether he really wanted his private counsel appointed?
And I'm happy to address all three of Your Honor's questions. Judge Lucas, I'm not sure how much time I have left.
You got about 2 minutes, but we're peppering you with a lot of questions, so I'll give you a little extra time.
I appreciate that, Your Honor. Make sure I don't overstep my bounds. I think I can answer all three of Your Honor's concerns in one answer, and that's by going through what the process is in this instance. The imposition of an ETG and specifically the removal of rights of an individual, an alleged incapacitated person, not a determined incapacitated person, but the removal of their rights and specifically the right to contract, the process to then retain private counsel is not removed from that individual. Now, Mr. Foster here did not have the ability to sign a contract, did not have the ability to agree for Mr. Denman to come in. However, Mr. Foster had the ability to express his wishes to Ms. Radulovich, his guardian, who then was the one who held the right to be able to hire Mr. Denman. That is the appropriate process that would need to be followed. And specifically to address the question.
Help me out with that, because again, the guardian is there based upon alleged incapacity. This gentleman does not lose all of his due process rights and his right to select counsel by virtue of the fact that there's been a petition filed and there's a preliminary finding that, yeah, he might be incapacitated. You seem to assume that the emergency temporary guardian of an alleged incapacitated person almost becomes like the sovereign. Help me out with that.
Your Honor, to clarify, Ms. Radulovich, the ETG, was appointed not because of a suggestion or a potential incapacity. She was appointed because there was a determination that there was an imminent danger, specifically as to Mr. Foster's property. It was not a plenary ETG. It was simply an ETG as to his property. There was no determination. We agree with Mr. Denman. At no point.
Wait a minute. So now you're saying there was no threat of incapacity, but no, I'm not saying these two things couldn't exist. There could be someone who's has perfect capacity, but say he's not ambulatory and someone's going to come rifle through his drawers or something like that. And so I don't know, but you're saying you're in a position now that you're arguing, well, it wasn't based at all on his capacity. It was some other reason why there was an imminent danger that physical or mental health or safety of the person will be seriously impaired, that the person's property is in danger of being wasted, misappointed, or lost. Is that right? It has nothing to do with incapacity?
I wouldn't say, Your Honor, that there's nothing to do with incapacity in the sense that the court would not have made a determination as to incapacity because there was no medical determination. There are no medical records that are reviewed. And simply because an ETG, as perfect example is here, occurred 3 days after the DCF worker filed a petition for a determination of incapacity, the ETG petition, and the petition for the appointment of a guardian. 3 days later, there's an ETG, which is not enough time, I don't even think, for the medical examiner, the examining committee, to have been appointed. So that's why the ETG statute does not require a determination of incapacity, but rather only that these emergency circumstances exist. However, we will acknowledge that the more evidence or the more concern there is as to incapacity, the more likely someone is to be either unduly influenced or to be exploited. So it's part of the consideration, but it's not a determination that needed to be made.
There's a continuum when we're talking about someone who is in danger of being exploited, or to use the statutory language, in suspects subject to the imminent danger of physical, mental health or safety, et cetera, property danger of being wasted, between the susceptibility to undue influence or overpowering, and then at the end of the continuum, complete incapacitation is what you're saying. Under 744.3031, you need not even allege any lack of capacity.
I think if I was forced to give a bright line rule, I don't know that there would have to be. Now, for an ETG petition to be filed, I believe the statute specifically requires, in subsection 1 requires a petition to determination of incapacity. So by necessity, there has to be a sibylline petition to determine incapacity filed at the same time. So there has to be under oath a petition asking this court to determine that individual is incapacitated. But in terms of the actual factual findings that need to be made, no, there doesn't need to be a determination of incapacity. And in fact, I would agree with Mr. Demon that had the court based the denial of the motion for substitution of counsel solely on a lack of capacity or a concern of a lack of capacity, that would have been error under Holmes and under Campbell, but he didn't. He based it upon specifically Jacobson versus Busco because the right to contract had been removed. I acknowledge in that decision there had been a determination of incapacity at that point, but that is not what the basis of that court's opinion was. It's specific.
Let me ask you this: you're speaking of case law. What are your best? What's your best case or cases for the proposition that under an emergency temporary guardianship, let's say whatever one that removes from the ward the right to contract, that ward cannot hire his or her own counsel under 744.331.
Your Honor, I'm aware of no case specifically identifying an ETG. And I'm aware of no case where this court has made that determination of the effect of 3312B. However, the two best cases I would rely upon are Jacobson versus Busco, which adopts in Ray Bachmuller, which is a decision from this court. Those focus on the removal of the right versus on the determination of incapacity. And I would rely upon the natural conclusion or the logical conclusion that should the court find that an individual who is the subject of an ETG with the removal of the right to contract is subsequently permitted to hire counsel without going through the guardian would create an exception.
Without going through guardian, but his counsel that filed something with the court saying, I am his counsel, went to the court I think Judge Rossi-Newcomb brought this up. He went to the court. He didn't just go off and, go to Mr. Demon's office and sign a, retainer agreement and then later just show up and start filing things. He said, I want to be appointed.
Correct, Your Honor. In the court on August 24th, which can be seen as Exhibit B to the motion, the transcript of which can be seen in the motion to determine confidentiality of records. Specifically, the court conducted an inquiry into, and that was the first part of the hearing. I believe it was structured as a motion for appointment at that time, and then subsequently transformed into the motion for substitution of counsel. But the court conducted an inquiry at that hearing, and I would direct the court's attention because I know I'm running low on time, but the court inquired into Mr. Foster at page 18, but specifically inquired as to Ms. Radulovich on page 22. And she indicated, had Mr. Foster, I apologize, at the point, the alleged incapacitated person, he has since been determined incapacitated. But had Mr. Foster indicated a preference or an intent or a request to me that Mr. Denman be hired, I certainly would have examined that. And the trial court in his ruling, one, relied upon Jacobson versus Busco for the removal of the right to contract barring representation, but then two, denied it without prejudice. In essence, I would read into that acknowledging that Ms. Radulovich may have a subsequent conversation with Mr. Foster that would warrant her to review that. Had she improperly denied that, then it would have been appropriate to determine if she had breached her fiduciary duties.
And that goes back to what Judge Lucas was saying about this exalted status of the guardian here. There's another way of reading these statutes, and that is that there is a time period when someone is in suspicion of being incapacitated where no one knows who to trust. When I say no one, I mean the court. And the legislature has potentially, the way one reading of the statute goes, directed the court to say, well, yeah, it's hard to know to trust, but this person hasn't been judged incapacitated yet, and he still gets his own attorney. Well, let me go back to the statute again real quick, and I want to say, you've acknowledged that in the first line of 744 through 301, that this ETG is only something that can be instituted after the filing of a petition for determination of incapacity. And in the statute that gives various individuals the right to file such a petition, it says that an alleged incapacitated person may substitute his or her own attorney for the attorney appointed by the court. But you're saying that that doesn't apply because an emergency temporary guardianship has other purposes besides a pending petition for determination of incapacity.
Yes, except I'll clarify if I may, because I know I'm over time, but I'll clarify that it's not that it doesn't apply. It's that Mr. Foster did not have the right at that time because of this other statute for it to apply and for it to be binding. If there was no ETG, then Mr. Foster absolutely would have been permitted to do this. Or even if there was an ETG, but his right to remove or his right to contract hadn't been removed. Then
I follow you. If there's a petition pending, go ahead and hire your own lawyer. However, once an ETG, which is obviously by statutory language pursuant to or in conjunction with the petition, once that's entered, you could potentially lose the right under 744.331 2B.
If there is a factual determination of imminent danger, and if the right to remove.
You have to have that to get the ETG to begin with.
Correct. Yes, Your Honor. And only if it's as to the right to contract. But yes, Your Honor, at that stage, then the individual would not, the right would still exist, but it would be exercised by the guardian, not by the ward in that instance.
All right. Any other questions? Okay. Thank you, Ms. Jamo. Mr. Denman, I'll give you a little bit extra time because we've got a lot of interesting issues to unpack here. So go ahead, sir.
Yes, Your Honor. The first point I'll make is this comes down to due process. Bottom line, it comes down to due process. I'll point out that the cases cited by my opponent, so it's clear, both the Jacobson v. Busco and the Brockmuller case, both of those were circumstances where the individual had been adjudicated incapacitated. Very, very significant, had been adjudicated incapacitated. The issue here is, I think as Judge Atkinson pointed out regarding the statutes, if we look at 744-1012, which is the legislative intent for the guardianship statutes, subsection 3 clearly says, by recognizing that every individual has unique needs and differing abilities, it is the purpose of this act to promote the public welfare by establishing a system that permits incapacitated persons to participate as fully as possible in all decisions affecting them, that assists such persons in meeting the essential requirements for their physical health and safety, and protecting their rights, and managing their financial resources, and in developing or regaining their abilities to the maximum extent possible, and that accomplishes these objectives through providing in each case the form of assistance that least interferes with the legal capacity of a person to act in her or his own behalf. This act shall be liberally construed to accomplish that purpose. And thank you for indulging me for reading that, but it's so important here because not all guardianships, and I don't make no aspersions against Mr. Radulovich here, not all guardianships are great things. They're not all brought by great people for great reasons to protect someone who really is incapacitated. As much as the ETG statute is important, the guardianship statutes are important to protect someone, I agree wholeheartedly with the ETG statute that allows a Band-Aid until there's an adjudication to prevent wasting of assets, prevent dissipation, prevent harm. But that's a Band-Aid. That's not designed. And if it were, then the legislature should have said, this is the way it is. In virtually all cases, when a petition for incapacity is filed, at the same time a petition for an ETG is filed. That's the way it works. If the legislature wanted that there be a lesser standard, that it just be based upon a showing of imminent harm to get an ETG, if that's what they wanted to say, would supplant the subsection 2B of 744-331, they could have done that. They didn't. And there's a reason they didn't, and it's to protect a person's rights. In every situation, there must be adjudication. What's very important here, in the August hearing, on page 17, lines 1 through 7, throughout the entire page of 17 to 19, the court does ask Mr. Foster what his position is. He said he wanted me to be his attorney. He said he wasn't happy with Mr. Kouskoudas. He didn't meet with him. He says it on the record, I want to hire Mr. Denman. He then, subsequent to that, submitted an affidavit that's also in the record. In that affidavit, he said, when my attorney stipulated to the ETG way back when, I had never even met him. I never agreed to that. I never told him he could do that. I certainly never said to him, hey, I give up my right to hire my own attorney. Never. And there was no finding in that order that's in the record, nothing that discussed anything that would give any person such as Mr. Foster any ability to understand, oh, this is saying that I can no longer go out and get my own attorney. It says you give up these 4 things: right to contract, right to control your finances. It doesn't say, by the way, you have no right to an attorney. And obviously I can't go back and appeal that. Obviously you can't go back and appeal that because of the time that has expired, which is why all of the cases say that before you lose your rights under 744-331-2B to substitute counsel, there must be a determination of incapacity. And the most important case that I would refer this court to is the Holmes versus Burchett case, which is 2nd District case 766, Southern 2nd 387, which is clear that the trial court's failure to conduct an adjudicatory hearing before finding that the ward did not have capacity to contract and retain counsel of her choice failed to establish the ward's incapacity by due process of law, which could not be remedied on plenary appeal. In this case, after the court's appointment, and what's really, really important about the Holmes case, really important, if you look to the footnote 2, this was a case where an ETG order had been issued. So it's exactly what we have here. And I think maybe that was overlooked, but here you have an ETG appointment, and the court still said that there must be, the court made rulings on the substitution of counsel without holding an adjudicatory hearing and without making findings based upon clear and convincing evidence that Holmes was incapacitated with respect to the exercise of her right to contract and engage counsel. The trial court did not make factual findings with respect to the exact nature and scope of her incapacity as required by these same statutory provisions. We conclude that under the particular circumstance of this case, this constitutes a departure from the essential requirements of law, which cannot be remedied on plenary appeal. And citing
Okay,
the Harmon
Mr. Denman, I've given you some extra time, but we're going to need to wrap this up.
Yes, Your Honor. One last sentence. As it said, as citing to Harmon v. Williams, a person is presumed competent to contract unless incompetency is established by due process of law. And under the SATA case, an attorney cannot stipulate away an individual's right to have an adjudication of capacity. And thank you very much for your indulgence and extra time.
Sure thing. Thank you both. We'll go ahead and ask you all to please exit the virtual courtroom, and then we'll ask the attorneys appearing, or parties appearing for Cosentino versus Sarasota County.
Thank you, Your Honors.
Thank you. Have a great day.